Welcome back to Law News Network. I'm your host, Jesse Weber. You're watching the testimony of Dr. Richard DeFranco in the Joshua Gaspar case. This is a case we are covering here on the Law News Network, and we believe it's going to be starting any minute now, along with the Henry Segura trial out of Florida. But as soon as we get the Henry Segura live feed up, we're going to be turning to that. But in the meantime, I'm joined today by Law News' senior editor and former prosecutor, Ronn Blitzer. Ron, great to see you as always.
Good morning. Great to see you too.
So many cases to talk about today, but I think I would be remiss if we didn't talk a little bit about Michelle Carter, the sentencing, which we will have in that case later on today. I believe it's going to be covered by Aaron Keller at around 2 p.m. I want to talk a little bit about the Michelle Carter case. We've seen ups and downs, a lot of things about this case. It's breaking new ground in terms of criminal law. But what we see today is a lot of analysis about what she's going to be sentenced to. Will she be given an adult sentence and sentenced to the maximum of 20 years in prison? Will she was charged as a youthful offender. Will she be sentenced to a Department of Youth Services until she's the age of 21? Will there be probation? Will it be a combined sentence? I'm curious what your thoughts are on what her sentencing will be.
My personal opinion about, I mean, maybe not what it will, but what it should be is on the lower end of this. I think she should be considered a youthful offender. I mean, she was in high school at the time that this happened. But on top of that, she didn't kill her boyfriend. I mean, she encouraged it. What she did was horrifying and awful. But when it comes down to it, this was a suicide. It was an encouraged suicide. It was a really troubling situation all around with, Carter, sending text messages, saying, do it, after, her boyfriend said that he wasn't going to go through with it. He was attempting to kill himself in a vehicle and then told her that he had stopped and couldn't go through with it. And she said, no, get back and do it. It's disgusting. And, I think justice will be served to a degree with her facing consequences for it. However, to convict someone of manslaughter for this in the first place is controversial. So I think to have an excessive sentence on top of that would be surprising.
Well, the judge in this case, when we heard his ruling, he said this isn't novel ground, this isn't new ground, and he cited a case from 200 years ago. So it was his belief that he's not doing anything out of the ordinary, but if you look at any other legal scholar, you look at anybody who's trying to analyze this case, they say it is new ground. We've never seen anything like it. So the idea, maybe that he would, I agree with you. A part of me was like, he's going to convict her, okay, but then to sentence her to the maximum might have been too much to handle. But I'm curious because we are going to be hearing some some statements made by the family of Conrad Roy III today during the sentencing. And I believe Kim Bosey, who's Roy's aunt, said 20 years may seem extreme, but it's still 20 more than Conrad will ever have. That's a good point. The point is she was convicted of recklessly causing his death. So we have a 20-year punishment for involuntary manslaughter for a reason. Now, having said that, you do have somebody who committed this crime when she was 17 years old, and she has been out on bail since the conviction. Does that play in any way in your mind?
Yeah, I mean, she's been out on bail, so clearly there was no need to keep her incarcerated during this time. This is not a case of someone who's going to be a serial killer who is going to go out and commit further crimes. This was a specific situation. There was evidence during the trial that she was suffering from her own issues. These were two troubled teens that resulted in a tragedy. And yes, Roy killed himself, when after Carter pushed him into it, but there's a strong argument that if it didn't happen then, it would have happened another time, whether she was involved or not. To sentence someone who was a teenager, who was 17 years old, to 20 years over text messages, as horrible as they were, and they were terrible, I think is a bit extreme.
Yeah, so I think what you're saying, and I agree with you, is the sentence is going to be today to show that she deserves a punishment, to set an example, but not to, it's not draconian. It's not going to be so severe as if she was a mass murderer and, you know, she was a 17-year-old girl, as opposed to someone who has a violent history, who's dangerous to the community, and we might see a different result. Then again, who knows what we'll see today?
Yeah, I mean, if you have a judge pointing to a case from 200 years ago and acting like, you know, that's, you know, plain case law, saying, oh, this isn't a novel issue, it happened 200 years ago. Like,
yeah,
that's a little ridiculous. I'm not
right.
saying that he's totally wrong by saying that there is no link between the cases, but when your best support for your decision is a case from 200 years ago, it's a little tenuous.
They're going to appeal this.
I'm sure.
Yeah, this case isn't going away.
Yeah.
This issue is not going away. So we are going to be covering that again at 2 p.m. today, or around 2 p.m. But while I have Ron here, I want to quickly turn to his analysis of the Henry Segura trial, which is our new case that we are going to be covering here on the Law News Network. This is a case out of Florida, the quadruple homicide. Terrible case, such young children, a young girl, his young girlfriend as well. This case is 6 years old. We've had 9 delays. It was only a few months ago that Segura's attorney had to step out because of a conflict of interest. Have you ever seen anything like this, a case going on for this many years?
I haven't. You have 9 postponements, so many changes in attorneys and judges over something that at first seemed fairly straightforward. You know, you have Segura, who is charged with murdering his girlfriend and her 3 children, one of them being a child shared by the 2 of them. These kids were 3 and 6. The 2 of them were, I think, there were 6-year-old twins and a 3-year-old. They were. The girlfriend was found beaten and shot. 2 of the kids, I believe, were shot, and another was drowned. And there was plenty of evidence pointing to Segura. Another former girlfriend of his had told investigators that she had seen him a few days beforehand and that he was angry and made reference to needing a gun. There were shell casings found at his home. So there's plenty of evidence linking him to this. But then you have more evidence that comes out over the years saying, wait, maybe it was someone else. You have a partial match for DNA of someone else. You have what seems to be a confession by someone who said that he ordered the killings in prison due to a connection with a drug cartel, which, you know, to me, you know, reading about this, it, seemed to come out of nowhere. And now there's a question of, well, how much of that information is going to end up being presented to the jury? So there's a lot going on in this case. It's a lot more than what first, it appeared to be. And I'm very interested to see where this is going to go.
Absolutely. I mean, let's talk a little bit about this other theory that the defense is putting forward. So yes, they do say they have evidence of a partial DNA match to someone else. Now, first, the idea is if it's anybody else but Segura, that could be enough to show reasonable doubt. But if they can link it to, and his name is, he's a Colombian national, Angel Avila Quijones, who's now living in Italy, and he worked for Los Zetas, which is the same Mexican cartel that Brandy Peters, the victim in this case, allegedly worked for. And there's this whole case, this whole kind of theory that she had skimmed money out on a cocaine deal, and that was the nature of these kinds of this terrible situation, this terrible murder. And the judge in this case actually said that even though he understands that Santos, his name is James Carlos Santos, who's a Vice Lord's gang member, and he claimed that he ordered the hit on Peters, even though that Santos's testimony has been excluded by other judges in the past, he's actually going to allow how and why he ordered the hit and who Quijones is in relation to the cartel. All that information is going to be admissible, but everything else is going to be hearsay. Now, we've seen cases before, when I'm specifically talking about the Aaron Hernandez case, when Jose Baez put out a different theory on that could have been a drug deal gone bad, something else. Just putting that theory in the minds of the jurors and showing that there is some sort of doubt out there, could that be enough to get Henry Segura off? I mean, the case hasn't started, the trial hasn't started yet.
Yeah, I mean, absolutely. Depending on how strong the evidence is, this could totally end up being a win for the defense, because despite all the evidence against Segura, if you can convince a jury that the victim in this case was connected to a drug cartel and that there is credible evidence linking members of the cartel to her, and a confession from someone connected to it saying that it was ordered as part of a cartel hit, that's a pretty strong alternative theory that would create, I think, more than just a shred of reasonable doubt. I think depending on what this evidence is and how much of it ends up going before the jury, it could be very effective.
Exactly right. The only flip side of it is it's so outrageous to even say that jurors might be like, we're not going to believe this. This doesn't make sense.
Exactly.
Which is
why it depends on how much evidence the jury's allowed to hear and how credible it seems. Because it does, like you said, it seems to be so way out there. You have this one theory of the case that this was a boyfriend who owed tens of thousands of dollars in back child support payments, who said that he needed a gun days before. He had reportedly lied to investigators about his whereabouts in the hours before the deaths. So that seems like your typical straightforward domestic violence murder case. But then you bring in this whole elaborate scheme of a drug cartel hit, and it's like, what? But if there's credible evidence, that could be all they need.
At the end of the day, it's for the jurors to decide which story makes more sense to them. That's what it is. That's what it is. Which story makes more sense to them. And as you said, a domestic violence incident like this, which is tragic to hear, which we hear happening all the time and we really shouldn't be, sometimes can make more sense to the jury as what happened here as opposed to some sort of, as you said, elaborate drug cartel situation gone wrong. The one part about this case I also want to talk to you about is, again, it's 6 years old. That's an advantage to the defense, wouldn't you say? Memories fade, evidence goes away. 6 years is a long, long time. Would you say that is an advantage to the defense as opposed to the prosecution?
It sure could be, because you're going to have officers who are testifying. You're going to have witnesses testifying in this case whose memories are going to be impeachable. If they seem to be a little too prepared, the defense could say, well, oh, wow, you remembered that much detail so many years later. Or if they're not as prepared, oh, well, their memories faded, you can't rely on them. At the same time, then they also have the defense of, well, my memory is a little hazy because it was so long ago. That doesn't mean what I'm saying isn't true.
Exactly. Okay, Ron, last case I want to talk to you about really, really briefly before we turn back to our coverage of it. Before we cut in with Ron, we were actually looking at the testimony of Dr. Richard DeFranco in the Joshua Gaspar case. Now, this is actually the doctor who prescribed the defendant methadone, which is the big issue in this case, driving under the influence. We're not talking about alcohol. We're talking about methadone, which is what he was prescribed. The whole issue that the defense is putting forward is that he wasn't really impaired, that it wasn't a situation of impairment. But at the end of the day, even if that is true, couldn't he have been driving recklessly, which they also want to put down? So this is two separate theories. I want to first talk about the impairment. We're going to be turning back to the coverage of this case as soon as we have a live stream, but I will be turning back to the prior testimony of Dr. Richard DeFranco about the methadone issue. I'm curious about this impairment issue. What were your thoughts when you looked at his testimony?
I thought it was very effective. You compare it to the later testimony from yesterday from Sergeant Gable, who talked about why he thought Gaspar was impaired, about how he was speaking slowly, he seemed confused, he had constricted pupils. When he took field sobriety tests, while he sort of passed, there were also issues that made the sergeant think that he was impaired. But then you have the doctor saying, well, no, he probably wasn't impaired because methadone doesn't do that. And he's talking about how there have been studies shown that it's fine to drive while taking these substances, and that these types of impairments would not result in from methadone, especially not the dosage that Gaspar was taking. He was taking, I believe, 70 milligrams a day, which was an average dosage. The doctor saying how he's prescribed higher to other people, and that in his estimation, it would not cause impairment. So, the sergeant on the scene could say all he wants about what he thinks may have been the case, but when the doctor says, no, this is chemically highly improbable, that's a pretty strong defense argument.
I agree with you, and if they knock that out and then it's only left with reckless, that's going to be tough because according to the prosecution, they changed it. He was only driving, Gaspar was only allegedly driving 65 to 70 miles per hour in a 60 mile per hour speed limit. Now that is driving over the limit, but we're not talking about 100 miles per hour. We're not talking about 150. We're talking about 5, 10 miles over the speed limit. At the end of the day, this could have just been an accident. A terrible accident, but an accident nonetheless.
Yeah, yeah, and earlier reports that I had read said that he had been driving much faster, but then, yes, I've heard since then that he was only a few miles per hour over the speed limit, not, crazy fast like, one might imagine or associate with reckless driving. And, he's in a situation where he's not going overly fast, he's, confused and startled while a car is passing in front of him, he stops short. He has a choice of either go onto the shoulder, which most people would probably do out of instinct, or drive into traffic, which most people would instinctively not do, and as a result accidentally kills this trooper. What is more problematic for Gaspar is that there's a strong argument that he shouldn't have been on the road in the first place, because he had a license, but he's allegedly lied on his application for a license by failing to say that he already had his license suspended. So, I think there's a very strong case that he'll be found guilty of charges related to that, and the fact that he probably shouldn't have been driving in the first place, even if he didn't do anything wrong while he was actually on the road. Just being on the road really hurts him in this case. Well,
you're right. He shouldn't have been on the road in the first place, but will that be enough to convict him? We will see. Ron, thank you. We're going to be turning right back now to our coverage of the Joshua Gaspar case.